Yeah, so all I said was I just think that let me just summarize what I said, just in case I record this. I don't think that co-ownership was ever questioned in the past because people sort of took for granted you could have the bundle of rights idea where you could split your rights up. Um, and if you think of property rights as the right to exclude, and if you think of property rights as the right to that emerge because of a response to the problem of conflict, and property rights tell you who can use the resource or more particularly who can exclude people from it, then if you have a contract between people that split it up, that also specifies who can use it as between them. So it's sort of like a contract is always seen as the law between the parties. It's not an in rem right good against the world like a normal property right is, but it's a right in personam right between the parties. And if you combine the contract and the property right, that specifies which of the two parties can use the resource at a given time and would still serve to prevent conflict. Um, I sort of wonder if part of their opposition is also rooted in not only in their in opposition to co-ownership is rooted in their opposition to in their idea of unowned property. The state-owned property is unowned because if you believe the state property is not unowned but it's owned by the taxpayers, let's say, then clearly those taxpayers are co-owners of the property until you get it from away from the state. So, if you have if the state steals A and B's property and takes the money and sells it, let's say, and takes the money and buys property C, you could argue that A and B together have a right to that property C. So they'd be co-owners of it in that way. So I just don't understand. I don't understand. Or you take another example. Let's suppose you hire a worker to go homestead land for you, and the land is unowned. When the worker homesteads it, he's the only reason that the employer owns it is because of the contractual obligation of the worker to transfer it after he homesteads it, to transfer it to the employer. So even there, you have a kind of temporary co-ownership situation. But anyway, what are your thoughts on it? I mean, I could be wrong. Maybe they're just being ultra precise, and maybe they're right that co-ownership, technically speaking, is not possible. But even if that's true, you could get the same results with a contract. Let me give one more example too, and then see what you think about this. Like David Gordon has argued with me that you can't have that there's a problem with wills because if you leave your property to someone in the future, that at the moment of death you don't exist anymore. So how can you leave it to them? And I pointed out, well, number one, you could just say, well, I leave it to you the moment before my death. You could always do that. And if you really have a legal system that is so anal about this and doesn't let you do it because you're dead by the time you give it away, you could come up with complicated arrangements to do the same thing. Like you could, for example, have a company that's like an estate disposition corporation, and you transfer your property to the agency to the company, but they grant you back the right to use it while you're living, and they also grant you the right to change your mind at any point in time, but they also direct that corporation to transfer it to your beneficiaries of your will upon your death. So there's lots of, and that would be the same result. So I don't really see why we have to be formalistic about it. If you can get the same result, then that's the same substantive reality. And it seems to me that whether you call this arrangement between two people who are co-owners of a resource co-owners, or that one of them really have to be the owner and the other one is just having a contract with the other one. If it's a husband and wife and they co-own it, I don't see why you say it's the husband or the wife that's the owner and the other one is just the user, because it's the same result. And I think the word co-ownership is an accurate way to describe that. So, all right, done my soliloquy.
I mean, with them in particular, I think one, they're being a little bit too literal. Um, I mean, at one point, Hoppe does say, I forget exactly where, that only one resource can have an owner and stuff. But I mean, and I understand where Hoppe is coming from, but if it's the purpose of property rights is to be able to interact with people without conflict,
Correct.
physical conflict. So if we divvy up property rights in an object in a way that there isn't conflict, it is perfectly compatible with like the libertarian conception of property rights. So, just for, easements. Uh, if I have an easement onto, say, my land from someone else, it's just I can use this land to travel whenever I like, and you would have a property right in that property, but it's not like, I don't know, conflicts avoided because the person can't block you from using it, can't prevent you from
Well,
using it.
I think that the response of the anti-co-ownership people to that they might grant that you can have an easement, but they would say that that's still the easement part is only owned by one person. But Hoppe himself, not only does he recognize like things like easements, but he also recognizes co-owners because in that chapter, I think it's in the Great Fiction, and it's from his article on I forgot which article it is. It was the one that was in Libertarian Papers, my journal. But in the first section, he talks about if you have like a community, a town, and a group of people, and they use this path for a common purpose, they've collectively homesteaded that property right. And if someone else builds a road on it, which they can do, because as long as they don't block the easement of the that was pre-existing, which is why you could argue that like the land enclosure movement stole some property rights because it put walls up and prevented people from using like forest land the way they were using it before. You know, you could say you could build your castle on this land and you might even start using the forest, but you have to let people keep using it the way they were using it before. So you would have not only would you have divided ownership, like you have a certain physical object like a tract of land and you have an easement over it or a right of use or a right of way or a servitude and you have the basic ownership by with someone else but also that easement could be owned by multiple people and like if you have like two people who share an apartment or share a building and they buy it together obviously they can't use the exact same space in the kitchen at the same time and they know that so they have an arrangement where the first one to use it gets to use it but if they come to a conflict then their contract usually says if we can't come to an agreement, then there's one of two things you do. You have to go to dispute resolution, and then the judge would look at the contract and decide who gets to use it in that way, or they just have to sell it. You know, if they can't use it peacefully together, like husband and wife, that's called divorce. That's what divorce is. They have to basically divorce. So again, there's a way, a legally recognized way that you can use to settle the dispute which is what the purpose of property rights are.
Yeah. Um, well, I'm gonna say one thing about that because I remember something that you were talking about, I guess a couple of years ago, but also I kind of want to touch on rights in general because it's obviously very interconnected. But I forgot what you called it. It was like an obligation or duty of something where pretty much when there's not intractable violence, but
Inextricably linked, something like that.
no, it was where even if we can't find a solution to conflict regarding a conflictable resource. I remember you said, I forgot, it may have been a couple years ago. You were saying that either way, they can't engage in that conflict. They still have this like duty or obligation of avoiding the conflict, even if everything else falls through. Um, I forgot what you
I don't
called it.
remember that, but I have written about that. There's sort of a kind of a meta norm or an obligation to do your best to try to avoid disputes and to engage in dispute resolution when there's a conflict and to have some neutral arbitrator settle the dispute even if it's just arbitrary because that's still preferable to violence in most cases I guess but
Yeah,
I don't know I don't remember what you're talking about in particular.
yeah. I wish I had looked it up because I'm just now remembering. I remember
Let
you
me ask you,
posted a
what are you
resource.
looking into this for? Are you working on some project or writing, or what's the purpose of inquiring into this?
I mean, it's been something I've been thinking about for a few years, off and on. I eventually am going to write an article. I have a lot of it in my head, but I need to just write it down. And it's about I've actually talked to you about it before, an essentialist take on rights. Essentially, without justification, just it's going to be a big, pretty much formal test where for a theory of property rights to be justifiable, conceivably, it must not pretty much be in contradiction with that.
Okay.
You know, uh, yeah. I mean,
That
we've
sounds a
talked about
little bit like what it was Hillel Steiner um talked about rights having to be compossible. Like that's sort of a logical any system of right, and libertarians sort of mention this because like your mainstreamers say things like, oh well, rights conflict, you have to balance them and all that, but libertarians always say, well no, rights can't conflict because you allocate them. The whole purpose of rights is to stop conflict, and you allocate them in such a way as that their nature is to allow people to avoid conflict. So rights can't conflict. So if you identify a conflict between rights, then you've identified a problem. um, so all rights have to be compossible. um, yeah, it will be interesting to see. I mean, Hoppe probably, like I said, Hoppe himself, he might have said that like the use can only be used by one person. But I mean, I've talked to him. I know he says
right,
he of course thinks husband and wife can co-own property. Um,
right. Well, I think it was.
it would be interesting to, these guys that are arguing with us about it. Do they concede that you can have a contract that gets you the same result, like that allows, say the husband owns the house, but the wife has a contractual right to use it. So do they just object to the word? Like, do they say, yeah, you can have the same result, but it's a combination of contract and property rights, but one person owns it, but we shouldn't use the word co-ownership. We should use some other word. Is that really their dispute, or do they disagree with contract as well?
Anytime I've seen them talk about contract in relation to this, it's almost like when you've talked about it with them and they replied and they're pretty much acting like you're saying co-ownership originates from contract, like you're saying, like the people that um, say rights are from contracts, which of course property rights have to precede contracts. I think that's what they're thinking you're trying to do instead of saying we can have these arrangements, these agreements, whether explicit or implicit, that avoid conflict, that allow for co-ownership. I think maybe they're thinking that you're just trying to get from rights from contracts and not have rights precede the contract. That's the only thing I can think of when I've been reading their stuff when they talk
Well,
about
and
contract.
this is a little bit of a tangent, but there's an interesting, and I don't think libertarians have explored this as well as they should yet, but there's something called contractarianism, like David Gauthier, these guys. And there's the mutualists who there's an aspect of that there too. And the idea is that there's an element in rights of mutual, what's what mutualism is about, of mutual recognition, which is true that rights as a legal matter, as a social, as a socially recognized sort of custom or whatever you want to call it, as a legally recognized enforceable set of obligations, like to respect these property rights, that does rely upon widespread social agreement, and there's a mutual aspect to that, which is sort of touched on in a way in argumentation ethics. Like the idea is that you have to agree to. Hold on a second. Let me pause this. I got to go to the front door.
All right.
Oh, my wife's got it. Okay. No, so the idea is that yeah, in an argument, you presuppose property rights with each other because I'm expecting you to recognize my property rights sort of in exchange for me recognizing yours. Now, that's not a contract in the sense that we mean contracts, but it's like a it's mutual agreement on each other's rights. It's mutual acknowledgement of respect for each other's rights, which is sort of like a proto agreement, you could call it, right? It's sort of the base understanding of property rights, of recognition of property rights, which implies that you need someone's consent to use their property. But the property right is the fundamental thing. The property right is recognized by all parties because they have to mutually agree to do that to have a civilized society. But then contracts is what comes from property rights, right? A contract is just the exercise of control by the owner over the resource. You grant someone permission to use it or you don't. And you grant that permission temporarily or permanently, right? And if it's permanent, then it's a transfer of property rights completely. If it's partial, then it's like it would lead to co-ownership or the bundle of rights being split up. If I have 10 acres and I can sell half to one guy and half to the other, I've split it up. Or I could sell a right of way over it, like a driveway right of way over it to someone. I mean, you can split these things up. Now, in the law, it is true that in the law there's debate among legal scholars about how to treat those arrangements, whether they're called real property arrangements or whether they're called contract arrangements. Or like in some states in the U.S., in Louisiana, it's one way, in Texas, it's another about how you treat the ownership of rights to the minerals underground. Is it a real property right that's a contractual alienation of the property rights, or is it a contract? um, or like or a lease. If you rent an apartment from someone, or if you lease an apartment, is that a real property right, or is that a contract right? And I think the way the laws handled it is not really that interesting or relevant because they've just dealt with positive law categories. How the libertarian code would deal with it, I don't think matters, and I don't think we have to decide that yet. That's to me a classification matter. Right. So again, that's why I'm not too worried about how the classification to me is just the label we attach to the normative legal reality of the rights to use of the parties of a co-owned resource.
Mhm.
I'm calling it co-ownership because we know what ownership means, and if there's two people that have similar rights because of their contract with each other, then it seems to me that the word co-ownership is a reasonable semantic way to express that legal reality.
Right.
So I don't know why these opponents of this idea. It seems like they think that the reality follows from the language, like the way we describe it sets in motion this legal reality. To me, it's the language just describes the legal reality, not the other way around.
Yeah, I think there's trying to be, I don't know, meticulous about it, but they're getting lost in the weeds. Let me think. Oh, I remember. So,
The other thing to think about is when they object to co-ownership, the only thing a libertarian can object to is aggression, right? So for me having some kind of policy that I'm advocating that would violate someone's rights.
mhm,
Okay, so like if I said, "Oh, there's a right for me not to hear obscenity," if that means I can use force against you to stop you from speaking obscenity, then you see that me positing that right would basically end up condoning aggression. But if I say that A and B have a contract with each other over a resource that specifies how they can use it, and that with respect to everyone else, they're co-owners, whose rights does that violate? They entered into it voluntarily. There's a way that they can settle a dispute if they have a dispute between each other. So whose rights is being violated by this concept? It's not clear whose rights are being violated. So it doesn't violate someone's rights to have a confusing concept, for example. I mean, they might not like the terminology, but having terminology they don't like doesn't violate anyone's rights. But go ahead.
just thinking. Oh yeah, so all right. A few years ago, I know, maybe 3 years ago, we were talking on Facebook about the specific definition of a right, and I didn't see the way you phrased it in your newest book. So I was kind of wanting to ask you a little bit about your thoughts on what you had said at the time, where we were talking about what a right was specifically.
Right.
Um, Pretty much you were saying that a right to X is a status whereby the use of force to prevent another's use of X cannot be coherently criticized. I guess that's still,
Yes. Yes.
yeah.
I actually don't know if I have that in the book, but the
I
closest
looked
I
it
get
up.
to it is there.
Yeah.
Is it in the book or not?
Not when I was looking it up.
Yeah, I mean, there's a thing by Sadowski which is close to it. I someday I may want to try to come up with a more elegant definition. Um, that's less the definition than the nature of what rights can be justified. I think the definition is more like a right is a legal claim that can be that can be uh, legitimately enforced.
Mhm.
So that would include bad rights and good rights, like laws that like patent rights are a legal right in that sense, but they're just not a justified right. They wouldn't be justified in that first sense because you couldn't coherently argue in favor of it, right? Um, yeah, I think that's the only thing I might at some point I've been trying to figure out the best way to settle this issue about this meta norms issue and also this debate everyone's been having lately about um, whether it's necessarily immoral to violate a right, whether it's a rule of personal behavior or just a rule that guides the formation of laws in society. And so then your personal behavior, it might not necessarily be a rights violation. It might not necessarily be immoral to violate rights, but it would still be a just law that could be legally enforced. I'm still trying to sort that out the best way I can, and that could affect that definition of rights because it would be not just the claim that it couldn't be coherently criticized that you use force to defend this resource, but that the legal system or the laws uh, that endorse the use of force to protect that right, that property, that resource couldn't be coherently criticized. So I do think that there could be some progress made on that.
Mhm.
I haven't done so because everyone has a primordial conception of rights that we take for granted, and that's what we're arguing about. So there's no better one out there so far, and I do think it could make some progress in libertarian theory to drill down into that issue, but I haven't really lately or yet.
Put in. Yeah, I looked through your book because I was like, when you publish it, I thought, oh, maybe he'll explain more about what we had talked about before, and then I didn't see it, and I was like, I'll have to ask him sometime. Let's see. What was I thinking about? I guess with that though, since right is more so about being able to exclude others. It's not so much about the use of, but more about the use of the prop or use of some property to or resource to exclude others from using a resource. Um,
Yeah, the reason I sort of um, changed the emphasis of rights instead of right to use, which is more casual, to the right to exclude, is because it emphasizes that I noticed that in arguments about intellectual property, people would say that. So when I pointed out that the problem with intellectual property is it gives the holder of the IP right the right to prevent me from using my resource as I see fit. In other words, it limits my property rights. And then their response would be, well, all property rights limit other property rights. So that there's nothing wrong per se with IP rights also limiting your property rights because you're and then they give the example, your right to swing your fist ends where my nose begins. But that's not a limit on my property rights. That's a limit on my actions, which made me realize, well, yeah, so owning a property right doesn't give you the right to use it as you see fit, which everyone recognizes when they say, "Are you still there?"
yeah,
Okay, your screen froze. Because everyone says you have the right to do whatever you want with your property as long as you don't use it to hurt someone else's rights. So they add that caveat as if they think there's a built-in limitation on your property rights that you can use it for peaceful things but not for other things. But that's not a limitation on your property rights, it's a limitation on your actions because what limits your ability to use your property in that way is the fact that someone else has a property right. But the fact that they have that property right means that I'm limited in any action that violates their property right. So if I own a gun and I shoot you with it, I can't do that because it violates the property right in your body. But
Hmm.
it's not a limitation on my gun because if I stole the gun and I didn't even own the gun, I still couldn't do it. So the prohibition is a prohibition on my action because of your property rights, which means that property rights are not limited by other property rights, but actions are limited by other property rights. Which means that what a property right is it's a right to prevent someone else from using it. Actually, ironically, what made me realize that was patent law specifically says that the patent right is the right to exclude people. That's why it's called an exclusive right. It's the right to exclude people. It's the right to prevent people from using your patented invention. But as every patent lawyer knows, that doesn't give you the right to use the invention yourself because your use of the invention might violate an earlier or broader patent of which yours is a subset.
Hmm.
And so that made me realize, well, it's not only true of patent rights, it's true of all property rights. All property rights are not the right to use, they're the right to exclude. So that's the reason I did that. You have to get to that level of specificity to counter the false arguments for IP, which is that a IP right is a limitation on others' actions and others' property, even though they haven't committed an act of trespass.
Right. I mean, what I like about that, really about that, I think is probably the most important part, uh, is that it shows rights are interpersonal. If we only had one person, uh, rights would not even make sense. It's, rights are practical and they deal with
Correct.
interpersonal stuff. So that exclusion shows it really puts emphasis on the exclusion because it's not about the use of it. You can use it by yourself, not in relation to anybody. But I guess also that's one thing I was thinking about.
By the way, what you just said, that also shows the importance of the distinction between possession and ownership, because human action as an economic and descriptive category would apply to Crusoe alone on his island when there's no one else around, and he doesn't own things. He doesn't have the right to use a thing. He doesn't have the right to exclude anyone because there's no one to apply that right to. Um, he has the ability to possess and use the thing,
Mhm.
which is why, for example, if you own a house, you have the right to exclude people from it. Um, it doesn't mean that that right includes the right to sing a song or the right to take a hot bath because there's an infinite enumeration of things you could do with the property. Um, it just means you can prevent other people from entering the house. And once you have that ability and that right, then you have the freedom within that border to do whatever you want. Which is why we talk about a sphere of liberty. The sphere of liberty means like a sphere of act. The reason we value freedom and liberty, and the reason liberty and freedom are a consequence of property rights, is because once you have property rights, it gives you liberty, right? But it's not like you have this primordial independent right to life or right to action or even freedom or liberty. Those are just consequences of your property rights being respected.
Right. One thing I was thinking about while we were sitting here, I didn't even, I guess I was thinking through when you were talking about thinking about the interpersonal part. Because one thing I was having an issue with was, okay, if if a right is all about excluding others from using it, could we really call it co-ownership when, you know, uh, you let someone into your house? Maybe they don't have, maybe you say you can't stop anyone from coming in. I can tell you to get out at any point. So the guest cannot exclude anybody from using the property because they could be asked to leave or, they could be like, well, someone else going to use it. I've got to leave.
Wait,
Uh,
wait, 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 wait.
but
Back up. What do you mean the guest can't?
so what I was thinking about was someone letting someone else use their resource, like letting someone into their house.
Yeah.
Um, let's say in this case, the homeowner's like, if someone comes in, you can't stop them. You can't stop them from using this house, just as an example. And the homeowner can kick you out at any point. And I was thinking, then does the guest really have any right regarding the house? But
Well, okay, okay.
so I was thinking, is that really any meaningful right? But then when you were talking about it now, it was like, well, the real emphasis is the interpersonal. Then it's still, while usually it is the right to exclude, I guess in this case it would be the right to use because it is still, it has that interpersonal part to it
Okay,
instead
yeah.
of just
I
being, if you understand what I'm trying to get at.
I think so. The way I would look at it is this. I mean, I look at contract as a sort of it's sort of a subset of the more fundamental ownership right. The ownership right is a right to exclude, but what that means is that um, you can grant permission or deny permission to use the resource. Now, you can do that in complicated ways. You can put conditions on it, or you can make it temporary or limited in scope or permanent. So I can allow you to if it's informal and temporary and casual and revocable at will, like if a girl lets a guy kiss her, or if hold her hand, or if you have dinner guests at your house for a dinner party, it's understood that yeah, you've granted consent to them, so they're using your resource, but with your consent. That's
Right.
sort of the the most bare case of contract because it's not usually thought of as a contract because there's nothing permanent about it and it can
Right.
be revoked at will. But that is the essence of contract is like the consent of the owner. Um, um, so when you have someone in your house as a guest, they're not violating your rights because you've consented to them using your house. Now the use they don't have the right to use it, but they they have the ability to use it without committing aggression because they're not doing anything non-consensual. Um, Now, if you're saying that if I have multiple guests in my house and they're wandering around and they have to avoid each other's space to avoid bumping into each other, is that what you're imagining or something different?
No, what I was thinking about was, uh, let me think through it. Because I was thinking if you let someone into your house, just like if you let someone stay in an apartment because they pay you rent or whatever, the renter would have some type of right, even if it's
Right,
limited
right.
in
But
scope.
again, that's more formal and
Mhm.
that's more time limited. That's more you've actually it's not as revocable at will. So in most cases, yeah, if I invite you to my house for a dinner party, then I can change my mind at any time. Just like the girl can change her mind if she's having sex or kissing someone or someone's holding their hand, she can just change her mind.
Mhm.
Um, Now there's an exception, like if I invite some guests to my house and then a big hurricane starts outside, then you could argue that now I have to let them stay until the storm passes. Something like that. But you could say that's an implied condition too. But that's not normal, and that
Mhm.
comes into play in the abortion issue. Um, uh, we, Normally, if you invite someone, you can change your mind. But if you invite a fetus into your body and it has rights, you can't just change your mind if that violates the rights to evict it. I mean, get into the abortion issue, that kind of argument.
Mhm.
Um, but in general, the bare consent can be revoked at any time. But if I give you if I own an apartment if I own a house and I rent you in a bedroom in that house for a year and I've made that irrevocable, um, where I can't change my mind, then they basically have a property right in that house, um, that's limited to a time of 1 year. It expires in 1 year, but for that 1 year, then the tenant has a real property right. That's why there's a
Mhm.
debate in the law about whether that's a contract or a property right. For libertarian purposes, I don't think it matters. I would say it's a real property right because the right to exclude people from that space is now transferred to the tenant. And that applies to me too, as the owner of the house. I own that
Mhm.
house subject to their right to exclude, so I can't enter their bedroom without their consent now, right? And then it's up to them who they let enter their bedroom, if they want to let their friends come in and something like that. Um, but that's not even a co-ownership thing. That's just a division of rights. So like they couldn't burn the house down or demolish the walls in it because I didn't grant them that part of the right. So there's a
Right.
divided ownership right there. That's why I can own a house and I could sell the right to, it's called a usufruct or right to use. I could grant you the right to live in it until you die, a life usufruct, a life estate, um, which gives you the right to use it until you die.
Mhm.
But you can't tear it down or sell it to someone else except subject to that right. And as soon as you die, then my naked owner, it's called the naked ownership in the civil law. There's naked ownership, it's encumbered by someone else's separate use right. But when they die, then that disappears, and now I'm the full owner again,
Mhm.
except subject to the state's right to tax it with property taxes, which is why really um, we don't have full ownership of anything as long as there's a state, because the state has this background overlord right over us. They have the right to jail us and tax us and draft us and regulate us.
Mhm.
Um, anyway,
Okay. I mean, I understand what you're saying. So pretty much if you don't have the right to exclude, then you don't really have a right. And I guess it really
that's
is
that's what the rights are. Rights are the
right.
right to exclude. That's what they are.
I,
Property rights are the right to exclude others.
I guess I was just trying to square the whole of, well, everything has to, if someone's using it justifiably, then they have to have a right in it. But I mean, really, they don't have to. If the owner is allowing them to use it, then they are justifiably using that resource without having to necessarily have a right. If they cannot exclude anyone, they're just, they're not in violation of the owner's right, but they don't necessarily have a right in it because they can't exclude others, but they're still
Correct.
justifiably using it. Okay. That makes it okay. That makes a lot more sense. I guess one thing at the end about co-ownership that I think even like Liquid Zulu and all them would have to agree with is when it comes to defense or restitution or punishment.
Hmm.
It
Yeah, it's
if
another thing. Yeah,
that has to be co-ownership.
if someone commits a crime against two people, I mean, let's say he does $1 million of damage to two people independently with one act of aggression. You know, he tackles two strangers in a crowd, and the
Hmm.
two strangers are now owed compensation from this guy. Let's say he only has, of course, these guys don't usually have any money, but let's say he has $10,000 of cash. That's all he has. Well, yeah, that's fungible. So you could say 5,000 goes to one guy, 5,000 to the other. But until it's divided, the way the law treats it is they have an ownership in division. It's called. They have an undivided right, 50% each to that
Hmm.
resource until it's sold. And if it was something that wasn't divisible, like a car, then they have co-ownership rights in the car. And if they can't agree what to do with it, just like spouses in a house, if they can't agree what to do, they have to divorce. Or if you have two people that inherit a house from their father, that's another question. If I own a house and I leave it to my two children, you can't say that A owns it and B has a contract right with respect to A. I mean, there's no reason to prefer A over B. So A and B both own it in equal undivided shares. And unless if they can't come to an agreement between each other how to use it peacefully without conflict, then they have to sell it. There is a remedy that's selling it and
Right.
splitting the proceeds.
Yeah. I mean, even in that case, which their biggest thing with, I think, co-ownership is that they think that there's going to be some type of conflict that allows for conflict or promotes conflict. But I mean, ultimately, if two owners disagree, then they go to arbitration. A judge can say, well, you know what, we're just going to sell it, split it
Right.
down the middle, or ultimately do nothing. Maybe the property or the resource just has to sit there and nothing gets done
Well,
with it. But it's
well,
still,
think about this. Property rights are not, if you just have a pure property right system that they seem to favor too,
mhm,
property rights are not self-enforcing. They're not physical laws. They can be violated, right? So property rights are just social customs. They're signals as to who is recognized as the owner of a resource if you want to respect their property rights, right? But and they're also there as sort of a legal fact or factum that can be taken into account to decide who has the right to use it if there's a dispute. So property rights presuppose that they're not self-enforcing, and it presupposes that there can be periods of time where we don't know until we have a dispute resolution system, procedure that settles the issue.
Right.
So it's just like if you have property rights, say, split land between two neighbors, A and B. There's a property line between them, but the world seems to be infinitely divisible. So if you get down to a small enough level, down to the millimeter, legal measurements become imprecise, and there could be a dispute at the very edge. Can I build my brick wall like within 1 millimeter of this property line, or is there, at a certain point in time, there will be an undecidability aspect to it, or an ambiguous aspect, which would need third party dispute resolution if people can't come to an agreement on their own.
Mm-hmm.
So there's always that potential. There's always that sort of inefficiency there, the background need for arbitration or dispute resolution, which is what you would have if you have a contract, divide the rights up between co-owners. In both cases, you have a set of principles which can be determined by a dispute resolution system when there's a dispute.
Mm-hmm.
And that always presupposes that when there's a dispute is that when there's a dispute between parties that are willing to not use force and to go to a third party to resolve their dispute. That if that can apply between property owners A and B over a resource like a piece of land, why couldn't it apply between co-owners A and B over the resource that they're sharing together? I don't see a fundamental difference.
Yeah, no, I mean, I think that they just are taking some of what Hoppe is saying too literal in a way. Um, and I don't know. At first, when I was thinking about co-ownership a few years ago, I was kind of opposed to it because it was exclusive. But then we talked about it actually a few years ago, also about Section 230, that episode where it was about that and Walter Block and
CDA 230, CDA Section 230.
yeah, yeah, because that was the last time we talked. But uh, no, I think it's just because they're just almost too literal. That's kind of how I was thinking about it, anyways.
Well, if their disagreement is just semantic and they want a different label, they're free to propose one. Okay, but if that is that really their disagreement? I mean,
Well, I think that also goes into their criticism of Hoppe's uh, owning state property stuff.
I get it. That's why I said this stuff.
Yeah.
This ties into the ownership of state property debate, and it also ties into uh, maybe even the immigration debate to a degree. But um, uh, yeah, I'm actually going to see Hoppe next week and in Prague. Maybe I'll ask him. Maybe I'll see if he'll do 5 minutes with me and get him to say on record that I talked to him recently about this. He told me, yeah, he goes, of course, there's no problem with a husband and wife co-owning something. I'll ask him how he squares that with his. He'll probably just say that, well, I was just talking like in abstract terms about a typical case of one owner needing to have a system of property rights that can settle a dispute between him and someone else who might want to use the resource.
Hmm.
But if you have a contract, then that's there, and that settles the issue too. But
That is
anyway,
the solution.
that
Yeah.
is the solution. Again, it's interesting how the law should classify that contract right. Like, should the contract right be seen as an in rem right, or part of property rights, or something separate? But to me, that's something that legal scholars in a libertarian society could hash out after the legal system is developed. It's not a detail that really matters that much.
Right now.
It's just interesting. And there's so many other issues that are like the unowned state property one is far more of a potential of a. I could see someone taking the other side of that argument. I think they're wrong, but I see why they argue that. But I just don't. I really don't see what their gripe with co-ownership is, because no one's rights are being violated. I mean, but the state ownership of property, you could argue that our conception of it is leading to rights being violated because by our arguments, the state has the right to exclude immigrants or something like that. So it's having an effect. So I can understand there being a dispute about state-owned property.
Hmm.
But again, if the state, let's say the state steals my house and they don't even compensate me for it, and they just like expropriate my house and they use it as a government office. I mean, if you say that the state legally owning it means it's unowned, then I don't have a claim to it anymore. And I actually think in Liquid Zulu, in one of his recent debates, he said something like, if you have state property and it's unowned and you come and homestead it, maybe you have to give some of the proceeds to the people that were expropriated. Well, then why?
Then they
That's
have an
sort of
ownership claim in it.
right. So he's sort of admitting that there's an ownership claim by someone that's a special claim that's different than the rest of the world. But that's all we're saying when we say state property is not unowned. We're saying that there's someone that's the rightful owner and it's not the world at large, which is,
Right. And
yeah.
all scarce, all conflictable resources have to have an owner for uh, a justifiable owner. Otherwise, property rights doesn't make sense because then there will be intractable violence
Well, I don't,
if
I don't, I think they have to have an owner when they've been appropriated.
right.
This is
Yeah,
sort
and
of like,
conflictable, yeah.
well, it's not just that. I mean, it's been a conflictable resource is potentially ownable, but that's one reason I disagree with Walter Block's uh forestalling argument that that libertarianism abhors unowned property, and therefore, if you block someone with your property from accessing unowned property, you're committing some kind of act of forestalling, some kind of act of aggression against libertarianism itself, which makes no sense because libertarianism doesn't have any rights. It's not a thing that exists. And it's just weird because it's almost like saying that I'm violating your rights by not allowing you to cross my property to get to unowned property. Um, but the only way I violate people's rights is to use their resource without their permission. But by assumption, the resource is not owned.
Mhm.
And then they'll say, yeah, but by you enclosing it, you're effectively owning it. I'm like, well, okay, I don't think so, because if I'm not intending to own it, I'm not using it, I'm not owning it. But let's say that you're right. Let's say that by enclosing a resource that I'm not using, that's not been transformed at all, I effectively own it. It's like, okay, well then I'm the owner. So I'm encircling it and I'm intentionally preventing people from transforming it because I want to use it as a virgin. I want it to stay virgin land. Okay, so now I'm the owner. Okay, so whose rights am I violating by not letting you homestead it because it's not homesteadable anymore because now I've homesteaded it. So like their whole theory is weird.
Mhm. So then okay, so it's not that every conflictable resource, or is it ever? I mean, if it's conflictable, then two people are already dealing with it, right? It'd be, I guess, potentially conflictable resources don't
Well,
necessarily
that's
need to be
another.
owned.
Yeah, I mean that's sort of that ties into this Austrian issue about the subjective nature. Like so, Hoppe points out that rights, the classification of a resource in economics
Mhm.
as say being a public resource or private, it's not an inherent quality of the resource. Same thing with capital goods and consumer goods. Their status as a capital good or consumer good can change from moment to moment and is up to the subjective evaluation of the user, right? Which is another reason you don't have a property right in reputations or in the value of property. You only have the right in the resource itself. But the point is the the nature of a good as being a good depends upon the subjective valuation of it by an actor, and in particular, one that's demonstrated in action, right? Um, but what that I think what that means is that if you have an unowned resource out there that no one is, it's hard to say that. Well, this one reason why if I claim an ownership right in your resource in an unowned resource, no one can object to that because they're not the owner of it. they haven't demonstrated their value yet at all by doing anything to try to get it themselves, right?
Hmm.
So the point is, if you conceive of a resource out there in the world that no one has tried to get yet, in a sense, it's not a resource at all. It's not a good, because for the same reason that goods can be capital goods or consumer goods or public goods or private goods in different degrees, depending upon the way people look at it or the way they value it.
Hmm.
By the same token, if something is not yet legally homesteaded and owned, it's not even, it in a sense doesn't exist yet as part of the
Right.
social world. That's all I'm saying. But yeah, in a physical sense, you could say that the world is composed of resources. Some of them are being used and some are not. The ones that are being used to prevent conflict, there needs to be property rights in those. Um,
Right. So, well, I guess I was saying was that if it's a resource, like you said, in the Misesian sense, where it's actually being valued by somebody, and there are people around, then it would need an owner for the
correct.
potential of conflict. Yeah.
Yeah, so then there's a question. So again, the word conflictable implies the possibility of conflict, which implies other
Hmm.
people. So using my terminology of conflictable resource instead of rivalrous, okay, would you say that if you have Crusoe alone on his island and he's using resources, are they conflictable? I mean, they're scarce resources, but they're the type of resource that there could be conflict over if there were other people. And if there were other people, then you would need to have property rights to prevent there from being conflict. But they're not really a conflictable resource when there's no one else around.
Right.
I mean, physically, they're the same type of thing. They're the type. So you could say that there's, a tract of land out there that no one is using. It's not yet conflictable, but that's just to me a matter of semantics. It's the
Right.
type of thing that when someone tries to use it, they can get a claim in it because it's a scarce resource over which there can be conflict. So I guess in a sense it is a conflictable resource.
Right. I mean, if we're talking about potential conflict and
Yeah,
Rousseau's by
exactly.
himself, then sure, potentially other people could come, but then that'd be the potential of potential conflictability confliction, which means there's no conflict possible.
Yeah, the
And
point is there's no rights recognized. The rights being recognized means they have to be recognized by someone.
yeah,
I mean, if I have a property right that's recognized, what that means is that other people that might want to use it recognize my right to it, and they're going to ask my permission before they use it. But if there's no one else to recognize it, then there's no property right to recognize. I just can possess it without. There's no one to interfere with my use of it.
right. Well, one last thing before I know you've actually given me more time than what
That's
you
okay. We
allotted.
go. Yeah, it's fine. I kind of I soliloquized, but yeah, go ahead. I got a little bit more time.
No, I just wanted to because I watched all of the PFS videos just like a
Uh-huh.
week ago, and then thinking about this co-ownership thing, I guess thinking about the voluntary slavery thing, semantics, but I mean, technically, I would say there's voluntary slavery in that a person who aggresses against somebody kind of in a
Oh,
way
sure.
consents, you know? So,
Correct. Yeah, and I in my yeah, I've argued that there's is nothing wrong with alienating the rights to your body. It's just you can do it by active aggression, but you can't do it by just
saying it.
saying a word,
Hmm.
by saying I promise to be your slave, and if you is not, that might even, all that does is that's a way of indicating your consent to be, if I enter the boxing ring or a football field, I'm consenting to being hit by other people. But it's not because it's a contract in the sense of one that I've irrevocably alienated my rights. Because I can walk off the field or jump out of the ring at any point in time. I can change my mind.
Right.
Um, so it's not an alienation of rights. It's just a temporary consent. Um,
Yeah, back to not a right, but more just justifiably the justifiable use of it.
correct.
Conflict free use of it. So,
It's justified because the owner's consenting. That's correct. Just like lovemaking is different than rape. I mean, they're the same
mhm.
act physically. It's just one has consent, one doesn't have consent. That transforms it to conflict or not.
Yeah. I had not thought about the difference between justifiable use and a right. I guess I always thought of them in the same thing, but I mean, not really. One's just the right to exclude, and one's using with permission, pretty much. Let's see. Really, I don't. Let me look. I had gotten some notes,
Yeah, if
so
you
I
think
just
about
wanted to.
if you think of justifiable use, uh, a use only needs justifying if someone else objects, and they're only going to object if what your use is interferes with their use, which is why we have property rights over things that are such that only one person can use it at a time.
Right.
But go ahead.
Oh, sorry. No, I was just looking at the notes I had written over the past couple of days. I guess I had thought at some point about, well, there may be some cases where just like you can't, just because you have a property right in a resource doesn't mean that you can justifiably use it. There's cases where you cannot use it. But also there has to be cases where you don't have you may have the right to exclude people, but you don't have the right to use it to exclude people in certain situations. So I
Oh,
was
I don't know.
thinking,
Wait. No, let me think about that. So
for
let's take
example,
about let's talk about the right to use something. So if I have a gun, if I own the gun, I don't have the right to use it to shoot you because I don't have the right to use your property that way.
right.
But if I don't own the gun, the same thing obtains. It's just my actions that are limited by your property rights. But let's say I consent to someone entering my house. Let's say I consent to 100 people entering my house for a big party.
Mhm.
They all have my consent to use my house in ways that would normally be trespass. But since I've consented, it's not trespass. But they're having that right just means that their actions are not objected to by any owners. It
Mhm.
doesn't give them any right to exclude.
Right. No, I was thinking about like if your right to exclude if you exercise your right to exclude a resource, maybe in a case that would mean that you would be violating someone else's right. That would mean that you really in practice could not exclude. Like you couldn't kick them out if there's like a hurricane going on. So you couldn't
Yeah,
suddenly decide to exclude
I
them.
think if you think that rights have to be compossible and there can be no conflict of rights, I don't think you can imagine a case where you have a property right but you don't have the right to exclude.
Right.
If you don't have the right to exclude, then it's because someone else has. I don't. I can't. Again, this is why I said that property rights are restrictions on actions, not on property, because
Hmm.
it's not a limit on property rights. So there never could be your right to exclude could never violate someone's rights. It's only your actions that violate rights.
Hmm.
A property right is the status of having the right to say no. That's all.
Right.
And that status, having that status, is can never violate someone's rights. It's your actions that violate people's rights. So I can't see how you could ever not have the right to exclude because exercising your right to exclude would violate someone's rights. Now, if you take that case the hurricane example, what we're saying is you don't have the right to exclude temporarily because you basically transferred uh you've transferred part of your rights in the house to someone like irrevocably for the duration of this emergency. This is somewhat tangential, but Walter Block would has this thing. It's back to the slavery issue. Like, you can bind yourself into voluntary slavery agreements, and so they said, well, if you can't do that, then you can't uh, you can renege on a voluntary slavery agreement. But what about the pilot of an airplane who who has agreed to be your pilot and he wants to bail out in the middle of the flight? Wouldn't that be murder? That would not be murder in our view because he's not a slave and he can do what he wants. But my solution to that is, well, if that was really a real problem in a libertarian world, if that was a real risk, then what you do is you have a temporary contract or a temporary change of ownership of the plane. And what you do is you say the passengers or the co-owners of the plane during the flight until it lands, they are the co-owners of the plane and they own that door, the exit door. The pilot doesn't have an ownership right because you need him to stay on the plane to fly it. So if he says, I'm going to leave, the passengers can say, no, we don't give you permission to open that door. We own that door, right? And they could use force to stop him from doing it. So he's stuck on the plane.
Mhm.
And so that's just one example of a creative solution you could use, but that requires there to be co-ownership, and it requires there to be contracts that can be temporary and of limited scope, which is what contracts are.
Right. I guess when I was thinking of that, after that, I was like, well, whatever definition would be in principle, because even if in that specific moment you could not exclude someone, in principle you could, So it's just something I was thinking
Yeah.
about, like, just in principle. But then with the, I think when last time I've heard you talk about pretty much things like the airplane situation, I think it was Rhinoc that you also mentioned, or we had talked about, I think actually in a Facebook conversation before, because you could do convoluted the contract and stuff with the pilot, I guess, or you could just say that he would be, um, was it causally, or how did Rhinoc put it? Pretty much his actions would directly lead to the deaths of
Right.
people. Uh,
Yeah, yeah, that's interesting you bring up Reinach. I'm not sure if Reinach, he has a lot of these various hypotheticals he goes through. That's my solution to the problem is like, so let's suppose you have um see, one reason I've argued that um one 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 reason I argue that you can irrevocably alienate your rights to your body if you commit aggression, but not from a mere promise, um, is because the typical justification for contracts is called detrimental reliance or promissory estoppel. It's the idea that if you make a promise and someone relies upon it to their detriment, then if you're not held to uphold the contract, then you're harming them. But the problem is that's a circular, as Randy Barnett and others have pointed out, that's circular reasoning because you're saying, well, they were reasonable in relying upon it because the contract will be enforced. But that's your argument that the contract should be enforced. So it's circular.
mhm.
But and that's the reason why you can change your mind if you agree to be a slave because you're not violating anyone's rights. Because if they relied upon it, then that's just a bad judgment on their part. Um, but if I commit an act of aggression, then I've changed the nature of reality. I've already caused the act of aggression to happen. I've already acted as if I'm the owner of your body when I'm acting as an aggressor. And it's too late for me to change my mind. In other words, it's already a fact. It's already been established. So the victim can say, I can use force against you to punish you because you use force against me. And I can't say, well, I changed my mind now. Now I disagree with aggression. It's like, yeah, but it's not like reliance where you can just change your mind. You've already changed things to happen. So my point is that in a normal contract, you can change your mind, but in some contracts, like the airline pilot example, so another solution to the airline pilot example, and you can use this in other cases where, like, let's say I'm walking a tightrope between two buildings, and I hire some guy to have a net below me to catch me if I fall. Well, if he decides to quit halfway through the job and walk off the job, and if I fall to my death, that actually causes harm to me. And you could say in that case, like Randak probably would, that it's the failure of the guy to live up to his promise that caused the harm to happen to your body. But that's because the process already started and it's too late for him to change his mind. Another example in the law is we say that there's no legal obligation to try to rescue someone who's drowning in a lake.
Mhm.
You might be a moral obligation, but there's no legal obligation. So if you fail to jump in and try to rescue someone, you're not violating their rights. However, the law says that if you attempt to rescue them, you start swimming there, you have to finish because other people watching might say, "Well, I was going to jump in to rescue the guy, but I decided not to because there was someone already rushing to his rescue."
Mm.
So by your starting, there's a similar doctrine in contract law about offer and acceptance. Usually, when you make an offer, someone can accept it by the mode of acceptance that you communicated would be sufficient to accept it. But you can always change. You can revoke the offer before it's accepted. That's how
Right.
contract law works. However, if the offer is accepted by some kind of action that takes time, like let's say I say if you walk across this bridge, when you get to the other side, you can collect $1,000. If the guy starts walking and he's halfway across the bridge and then I withdraw the offer, then it's too late for me to withdraw the offer because the guy's already done half of the performance. And if he continues on and completes it, then he can accept. He can say, "I accepted the contract by starting to accept it." So there's little cases like that which I think make perfect sense. So by
Right.
the same reasoning, I think you could argue that when there's reliance that's relied on in a non-circular way, then that can make the person who fails to perform his promised obligation, that can make him causally responsible for the harm. You could say the same thing about soldiers in an army. If it's a volunteer army and one guy deserts and causes the other guys to be killed, see, normally I think you have the right to desert from the army, especially if you're conscripted. But you can imagine cases where you're in the middle of the action, your performance is essential, and if you don't do it, it's too late for you to change your mind because without harm coming to the person. You can even make an argument like for surgery. Like if I promise to give you my kidney, I think normally I could change my mind. But if the surgeon's already opened up the guy and I'm on the table, and and they've turned away other donors, and if they don't go on with the operation, the other guy's going to die now because of my starting this process. You could argue. I mean, some people argue that for sex, halfway through the sex, the guy can't change his mind and he can't stop. It's too late for the woman to say, no, I think that's wrong. Of course he could. I mean, it might take him a minute to get his wits about him, but I mean, all these things are not special problems of libertarianism. They're just problems that would affect any justice theory dealing with the real world.
Yeah.
Just like emergency lifeboat cases are not a special problem for us. That people say, well, libertarianism wouldn't solve the problem of three guys on a boat, and there's only enough. It can only hold two people. It's like, yeah, well, communism wouldn't, or socialism in a welfare state wouldn't solve that problem either. Sometimes tragedy is possible, and there's no solution. And that's not because we don't have a magical theory that solves every problem.
I mean, a lot of those hypothetical situations are loaded and dishonest, anyways.
Yeah.
Uh, I mean, I used to be more into, I guess, analyzing those, but when you really look at it, a lot of people just frame it so that, oh, well, if you answer, I win, essentially. And I'm not interested in in those kind of hypotheticals. Like, here's this
Yeah, and to
convoluted
my mind,
hypothetical.
libertarianism just has to do a better job of solving problems when it's possible to solve them. If it's not possible to live in peace with each other, or if there's an emergency where there's no solution, then that's because these things are possible, and libertarianism can't be expected um, to solve problems that are intractable. I've never
So,
heard of any other theory solving them any better anyway. So what are they saying? That libertarianism works 99% of the time, and because it's not 100, we can go to a system that solves it 50% of the time? It just doesn't make any sense.
right. I mean, if two guys at the same time are going to reach down for a stick in the woods, who can grab it? Well, that's a
And that
yeah,
and that's when you would have a meta norm of an obligation to submit the dispute to arbitration. And maybe the only solution would be to flip a coin, but that still
right.
might be better than violence.
Exactly. I mean, that's ultimately the if we can't come up with a solution, arbitration, just not acting anymore with regards to that property, walking away, always options. Uh, but yeah, thank you for sparing me this time.
You're welcome.
I know we hadn't talked in a while. It's always fun. I know you're also busy.
Why don't you
So,
do this? If you get some more questions, I'm traveling the next until mid-January. But after that, I'll be free. So if you have some more questions, we can do it again and have more time next time.
okay, that sounds good. Well, if you don't put this up as a KOL, can you send me the recording?
Yeah. I probably will. I wouldn't say anything. Um,
Private. Yeah.
yeah, yeah, yeah. I'll put it up.
Okay. Well, thank you very much for your time.
Okay, have a good one, and I'll talk to you, say maybe in late January.
Sounds good.
All
Bye.
right, later.